What is a will? A will is a document that says who gets what and who is responsible for making that happen. Someone named in your will to receive your assets is called your heir or beneficiary. And the person in charge of making that happen is called your personal representative or the executor. It's important to note, though, that wills don't apply to assets where you have a surviving joint owner or to assets where you have a living beneficiary designated. For example, if you have a life insurance policy or a retirement policy where your spouse is named as your beneficiary, then that asset will pass directly to your spouse regardless of what your will says. If you have a will, and it's really important to have a will as part of an estate plan, you need to make sure that it's in sync with everything that's owned jointly and everything where there are named beneficiaries, so you make sure that it's working all together according to your wishes. For any property passing under a will, it's important to understand that the will has to be filed with the probate court and reviewed and approved by the probate court before the assets can be distributed the way that you said in the will. The executor or personal representative that you named in the will gathers your assets, pays any creditors who may be owed money, and then just ultimately distributes the assets pursuant to your wishes. A will is a document that does have to go through probate, and actually that's a myth that we run across. People think a will is a magical document that covers every estate planning scenario, and it doesn't. A will is critical, and you need one, but it's important to understand that the will go through probate before it's effective, and that's a will.